Oops.
Okay. Thank you so much, Peter, and really thank you for this opportunity. I've been listening in on some of the sessions and working with one of the teams, and I have to say that it's been just a really, really valuable experience to be involved in this. So thank you so much. And there's, a lot of different ways that we can come at this topic. So to some extent, I guess I want it to be a little bit free-ranging and make sure we cover what people are interested in hearing about and addressing questions. Although I do have sort of an outline of topics that I thought would be good ones to share with this group. Focusing on what do startups need to know. I think there's really two things, and one is make sure that you understand what the IP position or what the IP policies are of your influencers or your sources of information. New IP these days is really always built on some kind of foundation. And so when you're building off of someone else's work, make sure you understand what their IP approach is and whether, what their ground rules are. And to do that a little bit, it comes what comes into play a lot of times is a look at the open source licenses that might apply to, let's say, the open source software if you're working with some open source software. And there's two main types of open source licenses. One is a permissive model, the other is a non-permissive or copyleft type model. And the permissive model is great for people who are wanting to use the IP because it has very few restrictions. For example, the MIT license may simply require you to give attribution to the author of the code. On the other hand, the copyleft licenses like GPL have a lot of strings attached, and so they're really good for the licensor because a lot of times those licenses will require you to license whatever improvements you make to their technology under the same terms, and which means that basically you give them access to whatever improvements that you build as well. So take a look at that. Make sure you are comfortable with those risks inherent in the license terms. Another simple thing to do is just make sure that you give credit when you're, using an image or using a quote or, just respect the IP of others. This doesn't cost anything and very easy to be proactive like that. In terms of what you build coming out of this competition or any other endeavor for a startup. So I guess back on that subject, just you're moving fast as a startup, right? And a lot of times IP is sort of seen as something that slows people down. It's, you have to spend time with IP attorneys where you could be developing. It costs money that you could be using to hire high quality developers. And I think probably the best thing that you can do if you have to move fast and you don't have the resources to put into IP at the beginning is just keep track of things. Keep track of who your sources are. Keep track of who your influences are. And also definitely keep track of what you build and what you create in terms of date, time, and who the contributors are. And that doesn't have to be a very complicated or sophisticated inventor's notebook or anything like that. It's just, even if it's just in a Confluence or, some type of software management system, or even by email or Slack, some kind of documentation, something written down about what you've contributed and who is involved, and really about the time frame in which it was created. So that will go a long way to helping you protect your IP down the road when you have time or resources to do that. Very, very important is to know what the dates, is to keep track of your timeline for coming out of stealth mode, or publishing, or presenting at a trade show, or giving a pitch, or offering the technology for sale. Those things can kill a patent if you don't make a patent filing before you go public with a publication or an offer for sale. In the US, there is a 1-year grace period. So if you make an offer to sell your product on day 1, you have the next 12 months to file a patent application before you can no longer do that. Outside the US, not so much. Varies by jurisdiction, but in general, if you publish a description of your technology in a white paper or a technical journal, that can be used against your later patent filing to prevent you from getting patent protection. And so it's really good, really important to make sure that you know what your IP strategy is before you make plans to disclose your invention publicly in details that you would much rather want to protect.
Could I stop you and ask a follow-up on that? So, I mean, a lot of companies I see in the blockchain space especially put out white papers explaining their concept of how their tool is working, and with the idea that that's how they're going to attract investors or attract people to buy their tokens. They're going to have this white paper out there to simply explain their idea. But so from what I understand, though, if they put a white paper out there, or maybe if they're blogging about their idea or explaining how it works, maybe they have this unique token model, like they haven't created a new blockchain, but their model of how they do it maybe is different. If they start talking about that and later on they want to put a patent on it, that's something where they've blown it basically by talking about it publicly too much early.
It is definitely risky. Like I said, if you're only concerned about filing in the US, then you do have a year. Mm-hmm. If you're concerned about protection outside the US and other parts of the world, it's definitely risky. What I have found, though, is many inventors that I work with are savvy about that, and they don't put all of the details in their white paper or in their publication. They are very good about talking up their invention without really disclosing the secret sauce. So that is one way to do it. Another way, and this is there. There's so many different things to talk about, but the one thing I guess I want to share is that in the last few years, especially, I have seen the U.S. Patent Office and even outside the U.S. patent offices really making efforts to bring themselves into the 21st century. And they're coming up with more ways to try to help inventors, which is very encouraging, and small inventors especially. Some of the mechanisms that are available, particularly at the U.S. Patent Office, that may be helpful to startups and small inventors. One of those things is called a provisional patent application. This has been around for a while, this concept of a provisional patent application, but it's only available in the US. But what it does is it gives you the opportunity to file something with the patent office. And it doesn't have to be a formal, well-drafted patent application. It can be whatever documentation you have at that point. And What it does is it puts a stake in the ground to say, and gives you a date with the patent office to say, here is my filing date. And so a common practice with startups, small inventors, and sometimes even larger clients is to file that provisional application, especially if they only have a few days or a day sometimes before they're going out to pitch or before they're going to a trade show. So what we can do then is gather all the materials that you have written up to that point and put it in a filing to the patent office, and that helps preserve your patent rights at a fairly minimal time and expense. But it only does that for a year. So 12 months later, then you have to decide whether to continue with pursuing patent protection on the ideas and the concepts and the technology that was described in that provisional. But that is a lower cost way to at least put a stake in the ground if you're moving fast and you want to at least preserve the opportunity to pursue patent protection at a later date before you go public with it. And so you'll probably find, and those provisional applications, by the way, are not published. If you do nothing with it after 12 months, it just stays at the patent office. Only you and the patent office will know about it. If you decide later to follow on with a formal patent application, then it will eventually become part of that patent file, and it will be publicly available. But like I said, on the other hand, if you just let it go after 12 months, that's no harm, no foul at that point.
So in that sense of a provisional patent, just to follow up on that, that can just be like an idea or a concept, but it's not something that they haven't like necessarily written all the code yet and actually made a prototype. But if somebody has an idea, can they put that stake in the ground already? Like, I plan to do X, and here's my general idea of how I'm going to do it, but I haven't actually made it yet.
So in the general rule in the US, that's where I'm based, about, we represent clients and we work with foreign associates all over the world, but speaking as a US patent attorney, you don't have to have a working model in order to file a patent application. Okay. But what's happening now, especially in the last few years, is the patent office is wised up to people trying to protect business models when they haven't thought about as much about implementation as they should have at that point. So it's really, if you have at least a proof of concept, or can describe one possible implementation of it, then it's appropriate for provisional filing. Okay. But if you're just at the stage where you're saying, boy, I think blockchain could be useful to help in the food supply chain, you're not ready for provisional filing yet. If you have, you have to, be cognizant of what the state of the art is that's relevant to your project. So, at this point, blockchain is a known technology. And so just, in fact, I looked at a patent application the other day where the claim, the invention that was being claimed was basically, hey, we're using blockchain to help the food supply chain. And that's not going to be specific enough. You have to have some idea of what you're adding, what your contribution is to the state of the art that's new. And in the US and in Europe and other countries, there's two main requirements. One is that it be new, so it's never been done before. The other one is that it's not obvious, which is a little squishy, a little hard to explain. But basically, could someone in your shoes and a skilled person in the art, could they put two and two together to, come up with what you've invented? Or is there some advance beyond that, simply putting A and B together? So that's where we're looking for what is that C that you're adding to A and B. I guess getting back on the subject of other helpful mechanisms for small inventors, at the USPTO, there are reduced fees, filing fees for small entities and micro entities. So a small entity is a nonprofit or a university or a company with, I think it's less than 500 employees, as long as if the small entity is not licensing to a big corporation, then you qualify as a small entity. So if you're a small entity, you get reduced fees by half. So the filing fees are cut in half for you. If you're a micro entity, they're cut in half again. And so the main qualification for a micro entity is that your gross income level has to be less than, I think it's about 190K US dollars. So if your micro entity is really geared toward those independent inventors who want to make a patent filing, and then the US Patent Office is going to reduce your fees for that situation. Another mechanism that can be helpful to startups that a lot of startups use is the non-publication request. So normally when you file a formal patent application, I think it's pretty much anywhere in the world now, it's going to be published after 18 months. So it's going to be available for anybody to read after 18 months. With a non-publication request, it's something that's only available in the US. You can delay the publication until and unless a patent is issued. So that means that if you, for whatever reason, you decide not to pursue this patent application any longer, or it's just having trouble at the patent office just keeps rejecting it, you never, for whatever reason, you never get a patent, then it never publishes, and that keeps the information out of the hands of your competitors or out of the public in terms of the patent filing itself. The caveat to that is if you choose to use the non-publication request, you have to certify that you're not going to pursue foreign filing, because the publication rules are sort of a part of a global treaty. And so if you're saying you want to file with a non-publication request, you're basically opting out of that treaty and agreeing only to file in the US. So if protection outside the US is important to you, that may not be an option, but for a lot of startups, especially in the tech space in Silicon Valley, at least traditionally, the US market for software patents was the most important. I mean, that's definitely changing now, though.
Christine, to clarify on that point, hey, it's Bob. Are you allowed to file subsequently for international patents after you've gone through the process in the US if you've gone the non-publication route? Is it just a promise not to file externally elsewhere before the US process is through, or is that a sort of perpetual prohibition from seeking an international patent?
You can rescind the non-publication request. It's more of at that point it becomes more of an ethical issue. Did you intend to file? I mean, you don't want to get into a situation where you're routinely filing non-publication requests and then rescinding them, because then it looks like you always intended to file foreign file.
No, I'm just thinking in practical terms. Now, a lot of people are concerned about their ability to raise capital in this post-COVID environment. And so, the clock starts running and they may be earnestly pursuing it. But one of the rationales behind non-publication is, it might take 18, 24 months or longer to raise the capital you need to start implementing your idea and do a patent.
Yep.
They need to get advice from a lawyer like you on their strategy. But I was just curious if there's any flexibility in the rulemaking also being considered at this time because of the delays and being able to follow through and do the sorts of things you would normally do while you're patent pending.
Yeah. So not specifically as far for the COVID-19 type of initiatives that the Global Patent Office has put in place, not specifically with non-publication requests, but like I said, you can rescind your non-publication request. If deferring publication is important, one way to do that is to file a provisional application first, and then follow it up with a non-provisional application and a non-publication request. So there's different strategies to employ there. But on the other hand, sometimes you might want to have that publication as something that you can show investors, and that something, and also once it's published, it does become prior art to other people in the space. So as long as your application is not published, other people might be filing and getting patents, and the Patent Office may not be able to use your application as prior art against those. So, and there's trade-offs, and it's nuanced, and it really depends on the situation. Did that help, or that confuse things more? Okay. So another program that's available at the U.S. Patent Office is the First Action Interview Program, and this is an alternative. There's two ways to try to speed up examination, especially for software patents. A common complaint, and it's valid, is that it takes 2 to 3 plus sometimes years to get a patent, and by that time, we've moved on. And so there are ways that you can accelerate examination and get a patent within the Patent Office promises within a year for the accelerated exam program, and doesn't promise within a year for the First Action Interview Program, but it does speed up things. The First Action Interview Program doesn't cost anything, but what it does is it makes the examiner basically talk to your attorney earlier in the process. And so in that sense, you get engagement with the Patent Office sooner, and hopefully work through getting the patent granted faster. The accelerated exam program, you pay an extra fee, and then the Patent Office just speeds up the examination and gets it done. During COVID-19, the accelerated exam fee is one of those fees that the U.S. Patent Office is waiving for small entities and micro entities that are pursuing inventions to COVID-19 related, that are COVID-19 related. I believe the qualification also is that it has to be a FDA regulated technology. But if you meet those qualifications, you can request accelerated exam and get a patent quicker, and not have to pay the accelerated exam extra fees. So that's one thing that might be helpful. I guess I'm not sort of bringing it up a level. There's different types of IP protection, and they tend to complement each other as opposed to being duplicative. So copyright, trademark, trade dress, trade secret, patent, and actually utility patent and design patent even are protect different aspects of your invention. So part of your IP strategy is determining really which parts of your product are the key differentiators, and which types of protection, or are you going to protect different aspects of it using all of those available mechanisms. One interesting thing that people may know or may not know is that aspects of your graphical user interface can be protected through not only copyright but also design patents. So for example, Apple has design patents on its lock screen, or on its home screen, or even the background color of the home screen being black. If those are distinctive features that set your product apart from a consumer perspective in the market, as opposed to being something that's functional, then design patent might be an appropriate mechanism to protect those features. And the design patent is typically much less expensive to procure than a utility patent. It's a very short, it's basically just the drawings of what the design is. See.
So in regards to like design patents and utility patents, what if we have somebody who, here's two cases. One would be if there's a company, like let's say like McKinsey has a particular methodology that they're using for their consulting practice, or any consultancy for that matter, and they say like this methodology of how we analyze our clients, that's our methodology. Is that something that's patentable? And related to that is, or kind of a secondary thing, slightly different, is if somebody's looking at patent protection for minor improvements, goods that are derived from traditional knowledge. So maybe there's something everybody already knows, but they're making minor improvements or minor additions to it. Is that a patentable thing or not?
Okay, yeah. So the minor improvements, yes, as long as it's not, obvious.
It's that part C, not the A plus B.
Yeah, it's that
you
part
added
C.
something.
And if you can convince the patent office that, a skilled person wouldn't have thought of that, and, it's something that wouldn't occur intuitively to someone that's skilled in the art, then for sure, people, especially, large companies with huge patent budgets, do that all the time because they want to stay a step ahead of their competitors. And try to keep extending their patent protection beyond the life of the original foundation patents. So they will keep filing successive patents on smaller improvements. As to the first question,
I'm sorry to interrupt, just on that point before you move on. We're all accustomed to having updates to apps pushed to us weekly, monthly, depending on all the things we subscribe to. At what point does a newer version of a software is it sheltered under the umbrella of a previous release, or need to be reapplied to in order for those innovations that are embedded in a beta version or a version 3.0 of something that was already, protected?
Yeah, that happens a lot. It comes up a lot in the software world. And I would say from my experience, it's generally major releases, so going from 2 to 3 as opposed to 2.1 to 2.2. But it's very contextual. You have to look at what the features are that you're pushing out, and assess whether they've been covered or not. That's the job of the IP attorney. So,
do you ever have folks who are using a filing process sort of as part of their diligence to see if someone out there has already beaten them to the punch, so they don't waste a lot of their development resources and startup capital pursuing something that ultimately someone else is going to beat them to the market?
Use the filing process to do that?
Yeah.
I would say that in the last probably 5-ish years, there have been several different patent analytics tools. Some of them now are AI based. Some of them are just number crunching or whatever, statistics. But in fact, I don't know if Peter, you can if I can share my screen.
Yeah, let me switch you to being the host.
I'll just show you some. I did a couple of quick searches using one of the tools that I'm familiar with. I would say people are definitely using these patent analytics tools for competitive intelligence and for looking at market opportunities.
You can share.
That is one way that IP can be used as sort of a leading indicator. Let's see.
But do the interviewers at PTO ever tell someone early on in the process, gee, you're not going to get a patent for that because that is either guidance that's not obvious, or there's something else. Obviously they can't discuss patents that are pending, but if they say there's already something on the market that is too close to that, do you ever get a stop sign from an examiner early on in the process that will save you a year of time and maybe a year of R&D because you thought you had a unique idea, but one or two other people out there already had it?
Yes, absolutely. And that's what the examination process is really supposed to do. If your patent application has been drafted clearly enough to really explain your invention clearly, then the patent office can do a high quality search and give you valuable information. However, the patent office, typically the sources of information that they look to are other patents and published patent applications. Sometimes they do look now more, especially in software and AI, they're starting to look more into academic papers as well. But they don't look at, or at least they don't use in their rejections, they don't use like company websites or product advertisements or anything like that. They're really looking at technical disclosures, other patents, publications, and things like that. What was I going to say? Well, I wanted to figure out how to share my screen here.
Yeah, I'm in your host now, so you can feel free to share anything.
Here we go. So can you see this graph here?
Yes, we see the food and supply chain graph.
Yes, okay. So just talking about some of the analytics tools that are available now, this is just one that I used the other day just because I was curious. If I did a search just on these two search terms together, food and supply chain, you can see how the number of patent filings has just increased from 2001 to 2019. Now 2020, it's too early to have a count, so that data point's not relevant. But definitely it's an area of increasing interest as for patent activity. And this graph shows that the primary jurisdiction for the patent filings is the United States at this point. WIPO is the International Patent Office. And this is something I should mention too, if you're not familiar with WIPO. WIPO is the World Intellectual Property Organization. And if you are someone who patent protection outside the US is important to, you can file what's called a PCT, Patent Cooperation Treaty, patent application with WIPO. And it's a little bit pricier, say, than filing direct in the US, but it does give you the option to then pursue patent protection in many jurisdictions around the world at a later time. So you file one application at WIPO, you pay a fee, and then you can defer the cost of pursuing patent protection in other global jurisdictions for up to, I think it's 30 to 31 months. This is the last one I wanted to share is this. I did a search on just food and supply chain, and then I added the term blockchain, and there were no, according to this search, there were no patent filings with those three keywords together before 2016. And then 2016 and 2017, there were one each. And then 2018, 2019, there were four each. So I would say this is definitely an emerging emerging area for patent filings, which I thought was very interesting. But those are some of the types of information that people are using these analytics tools to identify. And then, I could drill down even further on those and look at who the filers are on those patents and what else they have in their portfolio. And there's just lots of different ways to look at the data, just like anything else. There's big data around patents. Let's see. In terms of, a lot of people have questions about, in terms of software, what can be patented these days in software. The regime for protecting software IP has sort of been disrupted since about 2014, major court case, Supreme Court case then, and has sort of slowly been ratcheting back since then. The US Patent Office has come out recently with some guidelines telling us the types of things that they will grant patents on in the software space. And those things include improvements to graphical user interfaces. They also include ways to train neural networks. They also include improvements to the way network traffic is routed. They also include improved ways of processing data in ways that improve the efficiency of how the computer works. So the main idea that we have to think about when we're thinking about whether we're ready to patent or not in the US and also Europe as well is whether we have something that is a technology. There's a technical solution to a problem, and it has a technical effect, or it has a practical application. The technical effect is the European language. Practical application is the US language. Basically means that it has to improve the functioning of a computer. It has to provide improved computer functionality. So it comes down to the way that you tell the story of your technology to the patent office. While your technology may have a lot of business benefits, a lot of benefits to consumers, a lot of benefits to farmers, to producers, to suppliers, to distributors, the patent office cares more about relative to the technology that existed before your invention, what does your technology do better? How does it make the technology work? And some easy ways to satisfy that might be to describe how that your technology controls another device. How it makes the computer run faster or more efficiently, things like that. So definitely AI and AI in the abstract is not probably going to be enough to patent, but specific applications of the AI are going to be patentable, and as long as your approach is described in enough detail that it can distinguish over sort of the broad general idea of applying AI to this problem. How am I doing? Am I answering questions?
We can jump into the questions now. One of the most recent ones we have here: what level of protection does an international patent afford you? So if you're operating in India, for example, you design a new product, you patent it. The intended customer and for the goods, though, are within the U.S. markets. You're not going to be able to force those manufacturers to cease and desist, but can you block acceptance of the goods at U.S. ports? do retailers have any liability? And this comes from John Poor, who I think is actually working on developing an
Okay.
idea in India as well.
Okay. Yeah. So what if your market is the U.S.? You would file, you foresee that the people infringing your technology would be in the U.S. or would be importing the technology into the U.S. You would definitely file for patent protection in the U.S. And there's something called the International Trade Commission where you can assert patents to block imports. So when you have a patent, you can assert it against anyone who makes, uses, or sells or imports the technology into the U.S.
And is there an advantage to, if you're not sure which market you want to be in, but you want to have your stamp somewhere or your footprint down somewhere, just be like, all right, well, the US is the biggest market. Maybe I'm going to be selling this in developing countries, but I'm going to put my patent in the US because, I mean, maybe because it's the biggest market, but will that also be helpful when you go to establish patents in other markets that you've done that first patent in a large reputable market, as opposed to like filing a patent in like a tiny country and then trying to like a year later go back to the US market and be like, hey, I actually thought of that. I want to file my patent now.
I think
Or,
so. In fact, this is kind of anecdotal evidence, but I had visibility into a couple of cases fairly recently where the applicant filed a PCT application, which is that international application, got a search report. But what they had decided to do was they decided to get the search report done by one of the global patent offices that it had the lowest possible price for searching. They didn't care about the quality of the search. They just wanted to minimize cost of the patent filing at that point. They got a favorable search report saying, yeah, your invention, we think your invention is patentable. But when we brought that patent application into the United States, the U.S. Patent Office made their own rejections. And so they really didn't give any credibility to the search report that was done by that other patent office. And by the way, that's through a mechanism, it's called the Patent Prosecution Highway. And it's a mechanism by which globally patent offices coordinate, work with one another to try to improve efficiency so that the same work isn't being done at 5 different patent offices. And so if the theory is through Patent Prosecution Highway, if you get an indication of a patentability or allowability in one of these cooperating patent offices, other patent offices, are supposed to give that consideration. And there are some jurisdictions that are known for better quality searches. The US and Europe are the two, especially for software. So yeah. And I guess another thing to note is that there is something called the Paris Convention, which gives you 12 months to file outside of your original jurisdiction and still claim the benefit of your first filing date. So if you file in the US today, you can still, within 12 months, file that application either as a PCT or directly into Europe, directly into China, directly into Japan, Australia, wherever, and that application will be given the benefit of that first filing date of today that you had in the U.S., and that's through the Paris Convention.
And again, do you need to be legally a legal person in the country you're filing the patent, or could say a company that's based in India file a patent in the U.S. even though they don't have a presence in the U.S.?
Oh yeah, absolutely. No, you don't have to be present in the jurisdiction. No, not at all.
Okay.
The rules are different in terms of who the application identifies as the inventor. So in the U.S., And I like to think it's kind of a moral rights thing in that the U.S. is very much, we file the application in the name of the inventors, and those are people. And then we don't file it in the name of the company. We file it in the names of the people who, the product of human ingenuity is what's being filed on.
I want to pull you back to something you talked about a little bit at the beginning. And Andrew was may have missed part of this, but we can still go into more detail of when you're a new company and of this, again, going through the steps of what to do at the beginning. You mentioned about having 12 months to file. After coming up with an idea, you mentioned about how certain things, maybe by your actions and your publications, are protected or not, or you give it. But if you could just go over that a little more. Andrew,
Okay.
I think if you want to elaborate, you're welcome to. He's operating in Colombia, but
I just wanted to. Okay, so we're trying very, very hard to pilot something that should be usable most everywhere. And so one of the biggest challenges for us has been to try to figure out where do you even start the clock on what, right? Plus, product is in motion. We're it's not a static thing. It's not like you invented it and it's done, and either it is or isn't the cure for cancer, right? So like most platforms, ours is in motion. Legal is overhead.
Right.
Overhead doesn't get you to users. I mean, so unless we are able to figure out a way, and we and other companies like ours are able to figure out a way that patent protection is both very obvious and creates some sort of a lockout that would allow you to either sell or sue with some incredibly high probability of winning, right? Mm-hmm. It's not that it's not something that you would think is necessary, but it is something that doesn't sound like air or food. Do you know what I mean?
Right.
So if you could give any guidance on, because we're working in Colombia and in the United States. We're a U.S. based company, but a lot of our users will be global South. We recognize that in most places where we might be working on the ground, our likelihoods of seeking redress from the courts is chiquitico. So I'm just trying to figure out how to best spend what money and when to start the clock. Yeah. I'm sorry if I missed some of the stuff earlier. My apologies.
No, that's okay. That's okay. It's probably hard. It's hard to visualize, and for whatever reason, I didn't put some visuals together. I wasn't sure how this conversation was going to go, but how do I want to say this? I think I want to say, so there's definitely a marker on your project timeline that will say launch, right? Or trade show. So you'll have some firm dates that when you're going to a trade show or when you're launching. And so you want to probably backtrack at least prior to that date to have a conversation about IP. But the conversation about IP, I think for a startup, it probably maybe a concrete way to think about it is who's going to copy, how easy is it for someone to copy what we're doing? And who will those people be? And if it's something that's really easy to copy and also, so how easy is it to copy and for them to make money off of it quickly, to basically shut us out? And so that would really be the primary factor in terms of deciding whether you need to file for patent protection. If it's something that is, if you have what you've developed is inside a black box, no one, you have to break it open. It's really, all of your talent is locked up in this black box. They're not going to leave and go start a competitor. It's just going to take them years or decades to discover how you've done it. Then maybe you can delay a decision on a patent filing. And trade secret protection can hold you for a while. So I think the easier it is for someone else to reproduce what you've done, it probably makes the urgency, it creates more urgency in terms of figuring out what your IP strategy should be.
Could you go a little bit more into trade secrecy of how that protects a young startup? And then after that, I'm just going to ask if anybody has any final questions to throw them in here, because we've already been fortunate that we've gotten Christine for more time than she allotted for us. So
thank you so much. Yes. So trade secret is a national, there's laws now in the US. There's a national Uniform Trade Secret Act, and there's also state level trade secret protection. The key is that you have to be able to establish that you made reasonable efforts commercially to protect the trade secrets. And what a trade secret is something that has independent economic or commercial value in and of itself. So it could be a customer list, it could be a secret sauce to Coke, it could be the way it could be the way you train your model. But the key is it has to be something that is capable of being kept secret. You can lock down your employees on NDAs, probably in other jurisdictions, not Silicon Valley as much, or non-competes are not as much available here in Silicon Valley. So there tends to be a lot of employee movement, or at least there has been historically, who knows after COVID, right? But so trade secret is a little bit, I would say it's good for those situations where it's hard for someone else to reverse engineer what you have, and it's capable of keeping secret. The problem is once it's out, and then you no longer have a trade secret. So if one person discloses it publicly, then you can enforce your trade secret rights against that person. But if then they tell two people and they tell two people down the line, it's much harder to enforce that trade secret now because it's not a trade secret anymore. So that's the trade secret.
And that trade secret, like say the recipe for Coke, if that's been repeated and it's been spread, can the company then, once it's become kind of in the public domain, they can't go back and say, hey, we want to put a patent on that, like they didn't put a protection on it early?
No. Yeah, I mean, but there are some nuances with trade secrets in terms of if someone sues you and you've been product is in the US, once a product has been commercialized for more than a year, the patent protection is no longer available as a general rule. But what attorneys are good at doing, or a lot of times, is figuring out what is still patentable, because a lot of times things happen, and you are moving fast, and maybe you did offer it for sale 6 months or 12 months or 13 months ago. Okay, so what haven't we offered for sale yet? And we can file on that and make sure we protect that.
All right. Well, I want to thank you for making this time available, and
I hope it was helpful.
It was, and I think there's a lot of new information and maybe new questions raised by some of the things too, and we could probably go down a rabbit hole asking you lots of questions for hours because
yeah,
it is really interesting.
It's been great meeting you guys, and hope to continue. Look forward to seeing the results of this hackathon and maybe continuing to build relationships after this.
Fantastic. Thank you again, Christine.
Thanks.